I'm Justin Plummer. Appreciate you coming out to our webinar this evening. Have a couple ground rules of which I'll go over, but basically going to go over a lot of information tonight. So I encourage you to write some questions down, and anything that may come up, we can certainly address at the end. I'll try to save some time for questions, but again, I'm Justin Plummer, one of the attorneys here at the law office of Cheryl David. All we do is estate planning, elder care. So appreciate you taking the time out of your busy schedule to learn a little bit more about estate planning. So what I'd like to do is kind of introduce our firm by basically trying to show you a little video, and then I'll talk a little bit more thereafter, but I think it's a great way to kind of introduce our firm. So.
I got a dreaded phone call. My sister was in intensive care. We made it up there and she passed away. She had contracted bacterial meningitis. And the thought that I could lose somebody so dear to me so quickly was devastating, and it made me rethink absolutely everything, but especially my career. Realizing that what we went through with my sister was something that happened to people every single day. And I thought if I could be of help when people are going through that horrible time in their life and make it a little bit easier.
My husband, Wiley Harris, passed away in 2017. And then I realized I needed some help. The human aspect means a lot to me. And some places are business, business, business to the end of day. But they have been very conscientious and they have led me into the right direction. She got some great people working with her. I just have full faith and confidence in the staff.
It's very special to me that we help families, but we're also a firm that's comprised of a family. It's myself, it's my daughter Blair, the other attorney that I work with, Justin Plummer. He's like family. The clients respond to this family atmosphere, and I think that they can feel that we really care.
Well, I wanted to ensure that my family would be taken care of.
We also first met Cheryl through his mother, who came basically to live with us after his father passed away, and so we would try to make it simpler when it came time for us to deal with her.
After we met Cheryl, she gave us the ropes, and transfer of the estate took a matter of weeks.
No one wants to talk about death, but it's something that's inevitable for each and every one of us. It's smart to come in and have a conversation, because if you don't have a conversation, you're not protecting those that come after you. We recommend that you come see us at the law offices of Cheryl David, and we'll sit down and we'll listen to you, and we'll try to come up with the best plan that we possibly can.
All right. So that was a little bit about our office. Again, for those of y'all that just got in on the webinar, I'm Justin Plummer. I'm one of our attorneys here at the office. We all do estate planning here at the office, but we each have our little niche areas that we specialize in. Blair, a law partner, is a board certified elder care estate planning attorney, nursing home, asset preservation. You can call that a couple different things. I also handle our probate and trust administration department as well. And that's all we do. So we're a little different in that sense that all we do is estate planning and elder care. So if you are here for a traffic ticket or something else, then you might be in the wrong place. But again, I encourage you as we go along, we'll be throwing a lot of information out there, and we try to pack it in as fast as we can, with as much explanation as we can. We're still trying to leave some time for questions. So I'll try to breeze through some of the stuff. But again, your gift for coming on to our webinar and sitting through it is a free consultation if you'd like to take us up on that. to talk about estate planning or, probate or any trust administration issues you may have, elder law issues. The only thing we ask is that you make the appointment within 10 days. And there's a link that my paralegal Ashley, who is helping me on this call tonight, has put into the chat. She'll try to put it in there a couple times just in case, but and we will save some time for questions thereafter. So without further ado, I think everybody's here for estate planning. I feel like the first day of class where the teacher's like, welcome to whatever 101. Everybody in the right place? Good. Well, I hope your week's treating you okay. I hope you're getting to a good start of summer. But with summer and different things in life, life happens. So let's talk about everybody's favorite topic, which is death, aging, and dying. Obviously, I'm joking, but the idea is that, this is a conversation that not many people like to talk about, which is one of the reasons why people never get around to having an estate plan in general. Why is that? Various and sundry reasons. People just don't know what's out there, or they hear something from a friend or a colleague or something, and that kind of makes it even more mysterious. Again, they just don't want to talk about it. Or they have a lot of very complex things and they like to bury their head in the sand and just think it's going to go away. Spoiler alert, it's not. So that's even more reason for, if you haven't got started on your plan, or even if you have a plan, it might be time to revisit it and maybe tweak it a little bit due to some changes in state laws or maybe just life circumstances. So traditionally, when I meet with clients, there's a lot of different concerns they have, but we can boil them down to a couple different ones. Most people don't want to have court intervention and pay money to courts that are unnecessary or burdensome to them. I don't know about you, but I would like to take those things off the table for my family. I think everybody realizes that the cost of nursing home care, especially in North Carolina, varies across the United States. But I think locally, last time I looked, it was anywhere from $7,000 to $12,000 a month, depending on the type of care and different health issues that may drive that. So obviously that can bankrupt anybody on a long enough timeline. For those of us that still have minor children, who do you want to be a guardian if you and your spouse or the person's biological parent are gone? You need to have that denoted within your will, or else there may be a guardianship hearing when you are gone. Nobody wants that. I'm not sure if you guys have the perfect family like I do. Wink, wink, nod, nod. But I find that every family gets into a little, fights or squabbles here and there. And I find that death and money change people, quite frankly. And it's very important for you to have those things kind of ironed out so that there's not any misinterpretation or any question about what's going to happen. At the end of the day, I tell people as an estate planner, what I do is I take your goals and kind of wordsmith them into documents and kind of the proper permission slips for when you need them the most. For many people, that goal may be, I don't want my children to have to go through court or probate when I pass away, or I don't want to lose my family farm or house or whatever to end of life care. Or I just want to make sure that I can protect the assets I've worked so hard for my children down the line. Whatever your reason is, it varies. The important thing is that you make sure that you have those wishes spelled out. The way I look at estate planning is that this is your opportunity for the state of North Carolina to tell them what you want to happen. If you are silent and you never get around to planning, trust me, they have state laws on the books that may or may not be what your wishes were, but the way they're going to see that is if you didn't give yourself a voice, then they're going to have one for you. So it's a way to think about it as to, this is your time to make your own plan and speak and have a voice for what you want to have happen. Over the years, we've done this a couple ways, but I think the easiest way to talk to people about estate planning is to show them kind of a real life example. So here's Bill and Mary Jones. Let's say they're a couple in their 60s in North Carolina. Let's say their estate's worth around $700,000. I know for some people that can be just a house, but that might be a house, brokerage, IRAs, different cash accounts, what have you, other assets, business, whatever. But let's just think of that in those terms. When we first start out, the first vignette is going to be if Bill and Mary had no estate planning, meaning they didn't have wills, trusts, they didn't have any financial powers of attorney, healthcare powers of attorney, no documents in place. And we're going to see how that goes for them. I got some bad news for you. It's probably not going to end well. I would say that planning applies to everybody. So if you're single, married for the 5th time, divorced, everybody needs a plan. So I always tell people that, people just think you have to have, what most people would consider, wealth or something of that nature. But, even if you only have a dog or whatever, who's going to get your dog? Who's going to take care of it? Would you give them some money or, children, what have you? So it takes all kinds. Here in this situation, we have John and Susan, the children of Bill and Mary. They're going to come into play here in a second. Let's talk about Bill in the sense of him having a stroke. So when we talk about that, there's a misunderstanding that sometimes that when you have a stroke or something of that nature, that your spouse is just going to be able to transact business on your behalf. That's false. When you have a stroke or something of that nature, and you're incapacitated, you're going to need the proper permission slips, namely a power of attorney for finance and one for healthcare, for you to be able to do something on that person's behalf. If you don't have those options, we're going to talk about guardianship in a second, but that is what happens next if you don't have those. Generically speaking, if you don't have any planning options, here are your options from 1 to 6. You can spend every last dollar. That never happens. I like that joke, but it never happens. You can die intestate, which means you don't have an estate plan. And I can promise you, many times that is not the best case scenario for your family, especially if you're in a second or blended family, as far as a second marriage goes, something like that. You can put everything in joint tenancy. That's not always a good idea to do that for various reasons. If you're trying to qualify for benefits later down the road, that can be seen as a gift. If it might put some issues in front of you with co-ownership of that. What if you have a falling out with, say, that child or that other person that you've named on a joint account? They can clean out that account. It's theirs. On homes, joint homes, I've seen some very terrible stories where the person just through love or whatever else put their child or somebody else on a deed to their house. And next thing you know, they can't kick them out, or, if they start bringing the wrong crowd around or what have you. And it's just, it can very, very easily complicate matters. You can have a simple will. We'll talk about that. Who's in charge, it names who's in charge and who's going to get what, but it's still a ticket to the probate process. And that's one thing I hope you take away from all this. You can also have a trust that's funded and also a trust that's unfunded. We'll talk about that a little bit later on. So most people, if you do have a will and you're married, probably you have something called an I love you will, which gives everything to each one of you if the other spouse passes or predeceases the other. But in this scenario, if Bill has that stroke and is now disabled and he doesn't have those powers of attorney in place, well, we're going to what we would consider probate court, but for a guardianship proceeding, okay? That means a guardianship proceeding is when you don't have a power of attorney, the court then has a hearing and looks and reviews evidence to see who and what person should they put in charge of your estate to make healthcare decisions or to manage your money. I can tell you've been through this myself. My grandmother had Alzheimer's and dementia and almost burned her house down. We had to place her when I was in high school, and she didn't have a power of attorney. And I remember my dad vividly having to go see one of our local attorneys in Concord, where I'm from, and had to complete a total hearing in which the person's healthcare documents and medical history are presented to the court. It's very humiliating for the person, even if they're not cognitively there. It's just it's a very unraveling publicly of your information, and not to mention all the court fees and attorney's fees and time and expense of doing it. These are not quick things. usually even getting a hearing is going to take a couple weeks or possibly months, just depending on the court caseload. So if you need access to that account or to pay this bill or that, I mean, you're probably not going to have immediate access like you would with the power of attorney, which really means it's a lot easier to have your permission slips before something happens. So if you're talking later, if Bill then passes away after that stroke, now we're going to talk about the probate process here, but I want to emphasize that if you have a surviving spouse that's left, most of the time there's not a full probate process until the second passing. You may have a smaller estate proceeding or a spousal allowance process, or there might be a car or some other cash account or something that's not jointly titled with the spouse. But just know that for individuals, think about it here, but for surviving spouses, there's not typically a big probate proceeding until the second passing. I handle probate. My paralegal, Ashley, who's on here, helps me handle probate proceedings. They are not fun. The first thing I will tell you is that just because you have a will, again, that is not going to curtail or get you out of the probate process. I think that's a very big misnomer that a lot of people in our world have. It never fails that we always have people who go to the local banks beside our office or somewhere else in town, and they get very frustrated when they're just trying to pay their parents' final bills or going to access money for funerals, what have you, that the accounts are closed and locked, and until they have court documents in front of them, the bank institution or really any other institution that's holding assets of the deceased person, they're not going to talk to them or transact business with them until they have the right permission slips. Well, the will may say that, Timmy or little Johnny is going to be mom and dad's executor, but the court has to bless that process and is really going to be a referee, if you think of it that way, for that entire probate process. The probate process takes anywhere from 9 months to a year, or, I've seen it 18 months. I have a couple that have gone on for multiple years. It really depends upon what situations are going on in there. You have to give notice to all the interested parties, all the beneficiaries. You have to give people a hearing opportunity to have a say. You have to put a value on every asset of the deceased. You have to put a notice of creditors in the local newspaper. You have to pay the court on the value of your assets that you're passing, $4 for every 1,000, and that's capped at 6,000, but that's quite a sum when you consider that. If you don't have a will, a lot of times there will have to be a bond that is put in place, which is you have to put up a certain percentage of money based on the size of the estate or assets. You'll have to do a final tax filing. It's a very convoluted and not straightforward process. The clerk of court in North Carolina cannot help you with the probate process. They might give you some forms to start, but most of the time I see a lot of people in front of me who have no idea what they're doing, or even worse, they've kind of gotten some what I call nasty grams from the court that say, hey, if you don't file this in X number of days, you're going to be getting a sheriff's notice. And let me tell you something, when you start getting knocks on the door from the local sheriff or deputy, that's not good. And, you can possibly be removed if you're not doing the right things. And so a lot of times people have to hire attorneys like myself in order to kind of guide them through that process, which is not a cheap process. Typically, between attorneys, court fees, executor fees, everything else, you stand to lose between 2.5 to 5%, maybe even sometimes 10%, depending on what's involved due to those costs. And so it's a very long-winded way of saying you don't want to be in court. It's very seldom that something good comes out of the probate process. It's very seldom. Again, this is a secondary job. For those of you who already still have jobs, if you've been an executor in a probate situation, you already know that it's much like, any other situation you previously had where you're working two jobs in essence. It's also very public. You can go and pick up anybody's estate file at the clerk of court's office, and that's public knowledge. And if you have real estate located in different states, you'll be doing a probate process in each one of those states. So if you're starting to hear the cha-ching of the money added up, you're probably right. It's a very expensive process. From an estate planning point of view too, after a loved one passes away, namely a surviving spouse, I'm always concerned from an estate planning point of view about them meeting a second spouse thereafter. And what kind of planning does that involve? Did you have planning prior to that new marriage? Do you have a prenup? How are we going to split up assets if it's a second marriage and there's a blended family and mixed children of different marriages? As you might imagine, it really matters how you do that, because once you marry someone, you have to leave a certain percentage of your estate to them under state law. I've seen some very, very sad situations where people didn't have the right documents in place and didn't ask the right questions, where on a second marriage, I've seen one side of a family get completely disinherited just based on who was the last of mom, or I guess new stepdad, to pass. And then it goes all to their children. So it's all very, very fact dependent and very important about how you structure these things. Secondarily, I'm sure I don't have to tell anybody that, while Mary is going to survive after Bill, the hope is that, maybe not in this market right now, but the hope is that over 10 years time, that sometimes, your entire value of your estate might double. Okay. And with the surviving spouse living an average of 7 years after the death of the first spouse, it's obviously there's expenses and other items you have to factor in there when planning for that kind of final estate. If Mary then has Alzheimer's and still doesn't have those powers of attorneys involved, and we have to go back to the guardianship proceeding, there's another trip to court there. Of course, nursing home care, I just told you, it's $7,000 to $12,000 a month, just depending on the level of care you need. And you can really, really, really lose a predominance, if not all of your estate in that regard. What I would say is also important is that now, depending on who the players are, if Mary's incapacitated and we're looking at a guardianship proceeding, now we might have some more infighting from the family. Is John or Susan the right person to be handling mom's affairs and making decisions? Are they going to be the right ones to account for every single bill that's paid for the rest of mom's life out of an account to the court every year? These are questions the court will take into consideration, and you just really never know how the court's going to decide on stuff like that. So in a world where you might have 4 different trips to court, 2 guardianships, and possibly 2 probate proceedings, that's quite a haircut on the amount of money that you could spend with all those types of things. I can tell you, even my own father, when he passed away suddenly after law school, that I had to take his estate through the probate process just because he had inherited some land from my grandmother. And of course, my mom's name was not attached to it. So that was in the sole name of my father. So we had to probate that. And so, it's one of those things where you want to make sure of these things, because obviously when you're gone or you're incapacitated, you're not going to be here to tell the court, oh, this is what I meant, or this is who I wanted in charge. It'll be too late to that point. Lastly, I'm always concerned about lump sum distributions. When you inherit something from an estate, typically that's coming directly to you. And once it touches you, if you have your own creditors or you have a divorce later down the road, I get worried about all of that money going by the wayside. There's different things you can do in certain situations, but we'll talk about that in a little bit. But I always get worried about that too, as far as management of that kind of money, especially depending on how old your child is, or maybe spending habits, or maybe, God forbid, substance abuse or something of that nature as well. I always worry about this situation because I've seen it. As far as Bill and Mary's children, what if, Susan's husband, what if that marriage is on the rocks, and all of a sudden, once she gets her inheritance, they've commingled it, paid off the house mortgage or whatever else, and they get divorced a year later? Well, that's too bad, so sad. There goes half of that money right there. If John's, kind of the ne'er-do-well, the failure to launch, so to speak, out of the house, What if he's got tax liens, or what if he's got some judgments against him, or he's behind on his bills and stuff? All those creditors that he has would attach to his money, and he'd have to turn around and hand it over to them too. So these are things to consider if you know these circumstances befall your family, or possibly could in the future. All of that's a really long-winded way again of saying, obviously, if you don't have a plan at all, then it's probably going to end up in those situations. That's the fallback. So obviously, I don't think we'd be talking tonight if there wasn't a better way to go about doing it. Again, I think about this whole process is, what are your goals? How do you want to see things handled? And how do you want your children to be affected by this process after you're gone, or maybe when you're incapacitated? I think trust work for predominance of people that I talk to would make sense given the nature of their assets. As you might imagine, my threshold is around 200,000 to 300,000 or more to make having a trust advantageous to you. Obviously, with a piece of real estate, retirements, all those types of things, you can get there pretty fast. So I've also done a trust for somebody with only $50,000 of assets, just because unfortunately their son had some substance abuse problems, and we knew if we left that out right to him, that God forbid he would probably be in a grave very soon thereafter. So there's not a one size fits all, but I would dare say that trust work most of the time fits people. So let's talk about what that means. You can get lost pretty easily in the what I call trust land, or the trust world. The trust we're talking about here is a revocable living trust. You might have heard it just referred to as a living trust, a family trust. Oftentimes people just use the word trust because they just don't have any other basis of knowledge for it. The idea is this: a trust works much like your will, except it's a will in a contract form. And the idea is that you put the same terms and conditions out there to the family, who's in charge, who gets what, maybe conditions around who gets what and when. But by doing it in a contract form, and also having those assets that you and your spouse, or yourself, if you're an individual, tied and connected to your trust, that basically will keep you out of probate and save you and your family a lot of time, heartache, and money. So again, I'm a visual person, so I like showing it this way. The magic of how you own things will drive what happens, or what needs to happen, when somebody passes away. The idea is this: if you are retitling your assets to your trust name, and you are connecting your cash accounts, life insurance, house, deed, vehicle titles, all those types of things while you were alive, in essence, what you were basically doing is you were fast forwarding through the probate process when you pass away, or when you become incapacitated. You've already got everything consolidated in the trust. So therefore, with that power of attorney in a trust, there'll be no guardianship proceedings, there'll be no probate or anything. So we'll get around all those other things that we just talked about. Obviously, that would be great. For a lot of reasons, we do this for transfer, right? I was explaining to somebody today, well, if you pass away with something in your sole name, the way that court sees it is that, well, you're no longer here to be able to transfer those items, and you're going to need court-issued documents through probate to get those items transferred, whether it be a cash account, stock, a home, vehicle, you name it, right? The idea is, though, by doing that with a trust, you've already done that legwork while you're alive, so that your family doesn't have to go through court and do the same thing. That's the big difference. You can also put some protections around those funds and those assets that are coming to, say, your children, or maybe your other family, or heck, your neighbor, for all I care. The idea is just, it's a lot more beneficial that way. Having a trust like this will not affect anything you do day to day as far as your accounts. It's only a change in title. You could still change banks, change checking and savings. You could change brokerage firms. You could buy and sell your house, purchase new homes, buy and sell vehicles. It's basically business as usual. It's just a change in title ownership, and it's still going to follow your social security number and all those types of things. So again, this is not going to change anything day to day. It's more of a change in, again, ownership, signature cards at banks, your title to your deed. Those things will change, but it will still be you or you and your spouse, just depending on your particular situation. I would be very careful when you're talking to people about a trust, or maybe if you already have a trust, in the sense that not all trusts are created equal. Let me talk a minute about that. When you have a trust, it's very important that the items you have and all of your assets are connected to it. If you don't have all of your assets connected to your trust name, then you need to revisit that planning, and you probably need to come see us or somebody like us, because you need to have somebody help you with that. Because basically at that point, the trust isn't really worth the paper it's written on. Because if you don't do that, you'll be back in probate court, and you'll be dealing with all those types of things. Unfortunately, I see a lot of people that have trust, maybe that the attorney's office did not help them with that, which is unfortunately very common. Our firm is different in that regard. I'll talk a little bit about that. When we set up a trust, we help establish that trust, and we also help that person or persons transfer their assets and connect their assets to the trust, so that when they walk out, they have something that's going to work. Not everybody does that, unfortunately. And as you might imagine, if you've taken a trip to the bank or talk to an institution lately, there's a lot of hurdles to get over and a lot of different red tape to even get online access and everything else. So I won't even begin to tell you all the trouble we see with some of those forms and that sort of thing within the trust. So I'm not going to belabor the point. Obviously, if Bill and Mary have a trust and they have those permission slips, like the financial power of attorney, healthcare powers of attorney, those types of things, then this is going to be a game changer. Obviously, it's not going to affect the outcome as far as their death or incapacity, unfortunately. Let me know if you know of something that can change that. We can talk about that later, but at least there will not be any guardianships. There will not be any expensive, cost of court or any need to go through court. If everything's titled in the trust name, there's not going to be any court or probate at Bill's death, and there won't be any issues for either one of their probates when both of them pass away. There won't be any, as long as everything's connected to the trust. Let me talk for a little bit about death taxes. It's pretty simple. North Carolina does not have estate or inheritance tax any longer, not since 2013. Federally, it is still around. However, it's not often I even see anybody that's anywhere near those amounts, and certainly not where they are now. Quite frankly, I think next year we always have to wait for what Congress and the IRS agree upon for the next year's amounts. But it's going to be somewhere 13 million plus per person for each person that's tax exempt. So you're going to have well over a $26 million estate to even have that tax. So if you have that problem, congratulations. It's probably the best problem you'll ever have. For the rest of us, we're still doing trust work to get around probate and to provide some protections to beneficiaries, but not as much for estate taxes as we used to, although it's always a consideration to think about. Again, if a married then is incapacitated, we're not going back through guardianship and no probate there. As you can see, it's night and day of those situations with a trust versus just having a will or nothing at all. I think, unfortunately, I think as I've been practicing now, this is my, 12th year. And I've had a lot of occasions to talk to a lot of different groups, individuals, families, what have you. And I just think it's this is not terribly new news for a lot of people, but I think a lot of people are creatures of habit. If mom or dad had something, that's probably what they had. If mom or dad or granddad or grandpa didn't have a will, they probably didn't. Or maybe, God forbid, something happened or, befall them that before they even had a chance to plan. So I just want to make sure that a lot of people understand that there's a misconception about trust work that you have to be a multimillionaire for it to make sense for you. And that's just not the case. So I think of the trust kind of like a tube of toothpaste, if you will, especially for divorce protections. And separately, you can do them for the tax liens and the judgment creditors and stuff of that nature, like we were talking about with John. But moreover, the idea is this: a trust can be like a tube of toothpaste, where with the trust you can turn off take off the end of the tube and take a little bit out and close it back up. Whereas if you have a will or no will at all, it's kind of like stepping on that tube of toothpaste and just immediately giving out all those assets to people. So I like that analogy because it allows you to kind of have some protections that the trust has, and that's a really good analogy for it. With most of the time, we're going to be just doing divorce protections for a lot of beneficiaries. Obviously, that's what I would consider a low-hanging fruit if you haven't looked at the divorce rates in America nowadays. But there's a 50-50 shot that might happen. Oftentimes, if you're interested in planning or what have you, we can definitely talk about the different options that are out there for, if a son or daughter has substance abuse issues or, monetary issues with spending habits or just has terrible issues of that nature. They probably need to have a neutral third party over their trust share rather than them controlling it. So that's a huge difference there. But we can, that's definitely a decision we can talk about, and definitely issues we can talk about. With the divorce protections, once Susan inherits that, it's held under the trust for her benefit. She still has access to that money if she needs it, but it's treated more as a rainy day fund. And as long as it's still held within that trust, it's not going to be taken from her when, God forbid, she gets divorced, which is obviously very good. We don't want half of our hard-earned inheritance that we're handing down to our children going to some new family. We just talked about that issue. We talked about having a neutral third party that can kind of pay items on behalf of John or, those types of situations. But it's important that, John can't touch that money or be in charge of the money because that wouldn't give him many protections in that regard. We also do that for special needs trust issues as well. If your child is, say, on special needs or family members of that nature, if they're on SSI, SSDI, these are situations, Medicaid, that we need to take a look at, because if the state has been paying items on their behalf, if they receive inheritance, they could be kicked off of their benefits. And of course, the way the state looks at it is that if they've been paying out benefits and you come into money, they'd like to be repaid. So we've seen some very sad situations where almost the entirety of somebody's inheritance went to somebody that was on, social supplemental insurance, SSI, and all of a sudden that whole entire, fund is gone for repaying back the state for many years of payments. So it's just a sad situation. We like to tell people that there are ways around that, and definitely planning options to create special needs trust or other options in that regard. So we talked about that. Let's see here. So with the assets, it still takes a little bit of elbow grease, once both people have passed away with the trust. But I always liken it to, it's kind of like driving to Disney World versus flying to Orlando. One with the court process being driving, and the airplane and airport into Orlando being the trust. You're going to get there a lot faster, and it's going to cut off much of the headache. In order to do that, you still have to talk to institutions, get death certificates, those types of things, but it's extremely night and day when I look at probate situations versus trust administrations. So be cognizant of our time here. I'm going to talk a little bit about long-term care and Medicaid planning and how that all fits in all this. I was just telling this to somebody today in the office. I think of estate planning as the big umbrella, and then maybe a little smaller umbrella underneath it would be considered elder care law. Basically, if you go to a nursing home, how can you protect some or all of your assets so that, God forbid, if the sick spouse, has to use up a substantial amount of those, how can we protect, a large portion of those to be protected for what we deem as the well spouse or the healthy spouse? It's a very common question. So we always say, obviously, you could use your own money. That might not get you very far with the amounts that are being charged per month. If you have long-term care insurance, that is wonderful. I encourage you to take a look into it and see if it's something that can fit into your budget. They make plans that just about every budget can afford. These things give us more planning tools in our tool belt and longer timelines for being able to do some things. If you're a veteran or you have people in your family that are, I encourage you to talk to your local VA ombudsman liaison, as they say. Every county has one, usually connected to their social services departments that can tell you what kind of benefits you can apply for, those types of things. Medicare is only going to usually pay for about 20 days if you have to go into a rehab facility or something after like a major surgery or something of that nature, or sickness or illness. Then they're going to politely tell you that you don't have to go home, but you cannot stay here. And then you're going to have to figure it out. Does that mean private pay? Does that mean that you don't have the assets to, so you can apply for Medicaid? These are the situations we deal with every day, namely my law partner, Blair, in the sense that we take a look at what we can do and what's there and how we can utilize the protections that law gives us legally to take advantage of those. What I would say to you is this, is that, you cannot just give away all of your assets and just, can't remember the phrase offhand. You cannot artificially impoverish yourself. You cannot make it look like you're just have nothing. There are ways around that. Let me just say that the one thing in North Carolina that's so sad to me is that I see so many people have their homes, basically with a Medicaid lien against them when the second spouse passes away, if they've had to qualify for Medicaid. And it's just the saddest thing in the world, because oftentimes that's been the family home or it's been passed down generation to generation. So you don't want that to have to be sold and the money go to the state. So there are ways to protect your real estate. So it's very important that even if you already know somebody in the nursing facility, it's important to have that conversation, because there's always something you can do for the most part. And at least having the conversation lets you know that. I can't tell you how many times people have come to us where they've already sold off all the property. They've already done X, Y, and Z. And we're like, I wish you would have called us 2 weeks ago, because you didn't need to do any of that, or you shouldn't have done any of that. And now we got to work with what we have. So there's ways to do that, and you have to work within the set of laws, which are kind of very convoluted in the Medicaid sector. But, on a good enough timeline, as long as we get in there pretty soon, we can usually save a substantial part of your estate from, nursing home costs. So we've been talking a lot about all this. I guess the whole important part of it is that this is a call to action for you guys if you haven't already. We obviously offer this service, so we'd be delighted for you to come in and talk to us about it, see if we make sense to work together. I love talking to people about this. I'm really passionate about it. I think I told you, my father passed away suddenly after law school. So unfortunately, the first legal thing I had to do with my new law degree was take his estate through probate. I'm an only child, so everybody's situation is different, but I like that unique perspective that I have, because I've been there. I've seen what my mother went through. I try to keep people out of that process. Again, with my grandmother's situation, Cheryl's got her same story, Blair the same. So we're really passionate about this, and it all hits us on a personal level. So this is not just a transaction for us. It's certainly trying to make sure that your family has what they need when the time comes. So if you want to work with us, what we traditionally do is this. Again, all we do is estate planning, elder care law. Again, we go through your assets with you, talk about a customized plan and what makes sense for you. We do not sneak around our fees. We put them right here. I'm going to let you know them in just 1 second. And then even after you've done your estate planning, we give you 2 months to kind of make free changes if you have changes in somebody's name, or maybe you thought about it a little bit more and maybe they're not right for a fit for this position, or maybe you thought about it and maybe your church or maybe your community organization deserves more money than a cousin or something. So we give you time to review those types of things. What I would say to you is this. I want you to take, whatever in your mind your estate is worth between life insurance, retirements, home, vehicles, all that, just a round number in your head. I want you to think about the 5 to 10% you could stand to lose going through probate, and let alone all the headache and hardships of doing that process for a year or so. And I want you to think what that could be as applied to your own estate. Okay. I highly recommend not going online to attempt to try to do your own estate planning. I often tell this, it's not really a joke, but I guess it's sort of funny. I tried to redo our bathroom a couple years ago, and about the third or fourth weekend I was trying to do it, my wife politely asked if I was ready to call somebody because I made it completely worse somehow, and I was. So this is not something you want to try to do, because if you have omitted a phrase, not used the right documents, you're potentially probably not going to be here to explain what you meant, and it might make it that much harder and more expensive for your family to try to undo what you've tried to do and help them. I have a horror story in my mind that many years ago, probably 8-10 years ago, one of the first cases I was talking to a lady about is her husband tried to do his own will, and I can appreciate, you know, somebody's tenacity and trying to do things themselves, but he had unfortunately, I mean, obviously it was a mistake that he had actually omitted her and disinherited her from his estate plan. And for what might have cost him $1,000 to do, she had to, you know, pay nearly $12,000 through court hearings and everything else to undo. So again, the grass is always greener until it's not, in that regard. So what we do is we do a trust plan for you as a package deal. So if you're married, great, it's the same fee. Or if you're an individual, it's the same fee. It's really the same amount of work for us, along with the trust and setting up and connecting your assets to it. We're also including with that package your pour over wills, powers of attorney for finance, with some nursing home protection language that we're able to use if we ever have to go down that road of elder care law, advanced directives, healthcare powers of attorney, HIPAA releases, and a smorgasbord, if you will, of other estate planning documents in it. So it's a very in-depth and involved process, but I think that it's worth doing, and you're saving your estate and your, you know, next of kin, loved ones, whoever you're involving in your estate, a lot of headache doing that route. Maybe, especially for maybe younger individuals or people that this doesn't make sense for, we do still offer kind of a will package route. This is not like an addition to that other number you saw. This is just a different choice somebody could make. Individually, it's $2,100 for a will, powers of attorney for healthcare, finance, HIPAA documents, and advanced directives, estate planning letter. So we try to give people options in that regard, but I highly encourage you, you know, do not put off tomorrow what you're willing to die, having left undone today. Whatever you do, don't let that happen. So with that, I think I've got 5 minutes for questions, but again, appointment must be in 10 days, 2 weeks. We're kind of malleable on that, but the reason we do that is often I find if we wait too much longer than that, I'm going to be reteaching you. You may forget things, and it's just easier for you to have some recognition of the items in your head that we've talked about tonight. If you're married, all I ask is that both of you have to be there. That's very important. So both spouses have to be there, or if you're an individual, it's pretty easy. And at the end of our conversation, a simple yes or no will be fine. Sometimes we're not a fit to work together. Sometimes we are, but a simple yes or no is fine. You're not going to hurt my feelings. We can see each other around town, part ways as friends. But that really is the situation there. Again, Ashley has put the link to our calendar so you can sign up, or you can contact our office. I think we prefer the calendaring appointment, as a lot of our prospective clients do, because you kind of get to choose your own appointment in that regard. Again, all we handle is that. So if you're not serious about moving forward with estate planning, or this is kind of just informational, that's fine. Please tell somebody at church, at Rotary, wherever, grocery store, something you've heard. You know, it's easier for us to do webinars and teach in this manner than it is for us to do it individually.